Welcome back to Justice Unfolded, where real courtroom drama meets expert legal insight. Today, we're diving into the explosive case of State v. Hancock, a defendant facing multiple felony charges, including evading arrest and continuous family violence. But here's the kicker. This isn't his first time before the court. In fact, the judge already knows his record inside and out. Now, watch closely. This hearing isn't just about bond reduction. It's about respect, control, and consequences. What happens when a defendant with a history of violence pushes the patience of a seasoned judge to the limit? Stick around, because you're about to witness one of the most fiery exchanges we've seen in this courtroom.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No.
This is ridiculous. And we don't have punks like you acting like this and treating us this way when we're at our job. All right, so you're Jasmine Hancock?
Yeah, no.
And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
Let's pause right here. This is a pivotal moment. The judge just referenced an emergency protective order and jail incident reports. That means there's likely evidence of misconduct even behind bars. In plain English, Mr. Hancock hasn't been helping his own case. Now, in legal terms, when a judge reviews bond reduction requests, they're looking for signs of rehabilitation or compliance, not continued chaos, missing a court date, defying officers, and stacking up violations. That's a one-way ticket to higher bond amounts, not lower dot. What do you think should prior behavior behind bars influence how judges set bond? Drop your thoughts below. I want to hear if you'd rule differently.
Increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well. Go ahead.
He's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off parole about 2 months before the new offense date in April.
Honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
Really? You're aware of that?
Yes, ma'am.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job.
Wow, listen to that. This isn't just a reprimand. It's a full-on reality check. You can almost feel the frustration in the judge's tone, and rightfully so. In the courtroom, respect isn't optional, especially when you're facing potential 25 years to life. When the judge says, "You've lost your right to make those decisions," it's not just metaphorical, it's literal. Incarceration removes personal freedom, and the court is reminding Hancock that actions have consequences. But here's the bigger question. Do you think the judge's approach firm, even harsh, is what's needed to get through to habitual offenders? Or does it risk escalating tension? Tell us your take in the comments.
The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny.
And there it is, the final ruling. No bond reduction, increased bail across multiple cases, and strict conditions, if released, GPS monitoring, house arrest, and a zero-contact order with the victim. This hearing wasn't just a legal proceeding, it was a masterclass in judicial control and courtroom authority. Judge, prosecutor, defense, each playing their role in a tense, high-stakes battle for accountability. What stands out most here isn't just the law, it's the lesson. Repeated defiance doesn't earn leniency, it earns consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. This is Justice Unfolded, where every verdict tells a story.
The motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient, and in that case I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition, in cause number 25 DCCR 0738 to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janesha Butler.
Janesha Butler?
Jamesh.
Jamaysha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. I don't know if you need to if I need something